Okay, we good? Who?
Well, we've got 13 with the guys that are standing up and 11 with everybody on the dais. And we need 12 overall. So,
Okay.
if you want to go ahead.
I'd like to go ahead and call the House Health Committee to order. Will the clerk please call the roll?
Representatives Alexander, Boyd, Byrd, Clemens, Freeman, Gant, Hakeem, Hall, Helton, Hicks, Jernigan, Kumar, Marsh, Mitchell, Ramsey, Sherrill, Smith, Vaughn, Whitson, Williams, Vice Chair Leatherwood, Chairman Terry.
Here.
Mr. Chairman, you have a quorum.
All right, thank you. And before we get started with the calendar, do we have any members with personal orders? Speaker Whitson, you're recognized.
Thank you, Mr. Chairman. I have 4 guests today from Bedford County. I have the Bedford County Mayor, Chad Graham, County Commissioner Greg Vick, their assistant Anna Frazier, and a friend of ours, David Trisdale. Y'all please stand. We're welcome today to the Health Committee.
Thank you for joining us. Any further personal orders from the members? Okay, seeing none, we are on our last calendar. We've got item number 1, House Bill 421. Representative Grills, you are recognized. And I'll need you have a motion and a second. And the posture of the bill is that it has an amendment 5551 traveling with it. And you are recognized.
Thank you, Mr. Chairman. Y'all know what the bill does for the most part, I do believe, but it prohibits the school system in Tennessee from forcing or coercing or requiring a student to take the COVID-19 vaccine as a condition of enrollment. Now, I do believe we have an amendment that Representative Smith and I have worked together on that she's going to file, and I'll.
Okay. We have an amendment we actually have 2 amendments that additional amendments that have been filed. First one is Amendment 7248 by Representative Smith. You have a motion?
Motion.
Need a second? Okay, you are recognized on that amendment.
Thank you, Mr. Chairman. And very simply, last week, the debate in this committee was we believe that this needed a kind of a sunset. And rather than, we talked about having, this applies to school children. So after 2 calendar school years, this bill will no longer cease to have enforcement activity on the COVID vaccine. And this will give the FDA time to study and gain an approval of COVID vaccines in the population that's being discussed, which would be school-aged. And with that, happy to take questions.
Okay. Representative Freeman, you're recognized.
Thank you, Chairman. And what would happen if that approval happened sooner than 2 years?
Representative Smith, you're recognized.
A new piece of legislation could be filed.
Representative Freeman.
Okay, that's it. Good answer.
Representative Mitchell.
Yeah, thank you, Mr. Chairman. I'm just concerned that, I've heard this entire legislative session, got to get the kids back in school, got to get the kids back in school. Well, we're getting the kids back in school, and I think the health and safety of the children ought to be paramount as well. And, I'd feel more comfortable with this amendment if as soon as the FDA approval goes through, that it would instantaneously take effect instead of us having to come back in and bring more legislation that would go through all this process again. I'm just hearing people, and I'm not referring to anyone in here, but I mean, too many people are talking out of both sides of their mouth. They want the children in school, but to guarantee safety and the health of the children as well as the rest of the population, if we've got something that solves this problem of this virus, I think it's in our poor judgment not to use the tools that science and healthcare are providing us to get us out of this pandemic. Thank you.
Representative Smith?
I appreciate my colleague, and I sit here as a vaccinated adult. I do know that at this moment, it's the Pfizer vaccine that has had a study population of some children in a pediatric setting. The others have not. I also know that as we sit here, the J&J vaccine has been paused to study its problems with clotting. And so while I'm willing to be a little more risk aware of some medications, particularly in children who are in development, and knowing that the fastest a vaccine has been approved prior to COVID was 4 years. Typically, that approval time ranges from 4 to 8 years. And in good faith, I worked with my colleague or our colleague. He was wanting a sunset of 3 years, and I was advocating, much like you, upon FDA approval. But I think that this is a nice compromise, that we've got a sunset of 2 calendar years of school, and and this again, it doesn't prevent children from getting a vaccine. It just prohibits this from being a mandatory requirement for being allowed in school. Again, if there is ample evidence of a safe vaccine upon approval and study, parents absolutely have the prerogative and the choice to have their children vaccinated. This just prohibits our Tennessee Department of Health from making it a mandate to access public schools.
Representative Mitchell?
Yeah, and thank you, Mr. Chairman. I just wanted to respond back. We keep hearing I think it's up to 8 cases now, the J&J vaccination. Well, there's been 8 million shots. There's 8 cases, so we've got 1 in a million. As I said at our last meeting, I'm not a doctor. I just play one every week in this committee. But we've got 2 doctors sitting in the committee here today. I think vaccines, in general, there is a higher risk of 1 in a million. Someone would have a reaction to a vaccine of all the vaccines that we've had for the public over the last 75 years. So that's not any reason to use that in the scare tactics of the Johnson & Johnson vaccine. Thank you.
Representative Smith?
Thank you, Mr. Chairman. And while I do appreciate the comments, I would just simply say all this amendment does is it adds a calendar year of 2 school years that this would be sunsetted. Just like broccoli and spinach, I know that those are 2 very healthy items. We don't put into code the requirement for kids to eat broccoli and spinach to be allowed into school, but it doesn't prohibit parents from feeding children broccoli and spinach. I think that while I understand that you're making good remarks, I would just simply say this is a good compromise to allow us plenty of time to see the COVID vaccine studied, put into use. It does not prohibit parents from getting their children vaccinated. It just gives a window of time for our Department of Health to look at this vaccine and provide an opportunity before it's put into the panel of required vaccines for admission.
Thank you for those comments. And I would like to add, doing research on those that are school-age children, going through that process, having that emergency approved at that age, then having it approved, there is a process, and then there's a process by which if a vaccine is added to the school, It still has to go through rulemaking process, still has to go through GovOps, and there's some other legislation around that. So I would think that the two-year window probably falls below that as well. Chairman Ramsey, you recognize?
Thank you, Mr. Chairman, and I do appreciate the compromise and the hard work that Chair Lady Smith and the sponsor put into this, and trying to make it a better facility for our citizens. The question had arisen, would all aspects of this bill be sunsetted at the end of 2 years? And I just wanted to hear the intent on that.
Representative Smith?
Thank you, Chairman Ramsey. Yes, this puts a 2-year, this puts a sunset at the end of the school year, calendar year, I think it's July 1, 2023. The enforcement of this bill terminates.
Thank you very much.
Thank you, sir.
All right, Chairman Kumar, you recognize?
Thank you, Mr. Chairman. FDA approval of a vaccine or any drug, their obligation is safety and efficacy. I didn't know what further needs to be done as far as safety is concerned. If we were to just take the Moderna and the Pfizer vaccine, 60 million doses done, no side effects, of serious nature. So I think that, I would think it's reasonable to say these are safe.
Representative Smith?
And I appreciate, what I want everyone to understand is I sit here vaccinated. I've given vaccines. I believe in vaccines. I think that what we're trying to do is bridge a compromise to, particularly with those parents who have fears. And some of these fears are justified, some of them are not. As you all know, if it's on the internet, it's true in the minds of some. And it's a difficult position to be in. But relative to government mandates and things such as that, we're having to come up with a good compromise. Last week, I made a commitment to my colleague to work with him to get this bill in a better position, and I believe I have kept my word, but by no means does this prohibit parents from getting the vaccines at all. And so, again, if you don't want to add the amendment and you're happy to move forward with the bill as submitted, happy to do that as well. I'm at the will of the committee. Thank you, sir.
Chairman Kumar?
Thank you. Chairman Smith, I think, yes, the bill is better, in a better position with the amendment, no doubt about it. But it's just not a good bill. That's a separate matter. But what I wanted to say was safety speaks for itself. The matter in front of us speaks for itself that these are safe. Efficacy also speaks for itself. Even few people who do get COVID, despite after vaccination, the disease is very mild to moderate. There have been literally no deaths after vaccination has been given. So I think given those things, FDA approval, just as a thought process, is I think it will happen earlier than 2 years because FDA should be able to read the newspapers also, in addition to just the scientific magazines. And again, considering the FDA's mission of safety and efficacy, which has already been proven and filled by if we're going to call it trial, it's the largest and fastest trial ever by giving it to so many people. And I think the matter should settle down. I would have some questions, Mr. Chairman, for the sponsor of the bill. His emphasis is towards, again, liberty and freedom of the people so they can choose. And I think I would like to ask him when we get back on the bill. Thank you.
Thank you. Any response, Shirley?
I would just simply say that, again, this is not an anti-vaccine amendment. It's simply, and nor does it frame anything in the context of efficacy or safety. It just permits a parent to send their children to public school without the mandate of this COVID vaccine until there's an ample window of time, whether it's through FDA approval or a window of time to show efficacy without harmful behavior. It does not prohibit a parent from making the decision to have their child fully vaccinated.
All right, thank you. Got another member, but before we get to that other member, I have some clarification that we need to get on the amendment. And for that, we're going to need to go out of session and have legal services discuss that. But it is my understanding that the amendment only impacts Section 1 and does not impact Section 2 of the bill. So without objection, we'll go out of session.
Matt King from the Office of Legal Services. Yes, Chairman, that is correct. The bill, as it comes to this committee, was amended in the House Education Administration Committee. That amendment effectively added a Section 2 to the bill. The amendment that we've just been considering adds to Section 1 of the bill that this section is repealed on July 1. That speaks to that section of code that it would create. That part, which is essentially Section 1 of the bill, would be repealed in 2023. However, that repealer does not affect Section 2 of the bill, which amends 49.6/5001B2, removing the epidemic language. That change would remain after July 1, 2023.
Well, we're still out of session here. Representative Smith, do you have clarification?
So as I understand, Chairman and legal, that the repeal is on the COVID, the vaccine, the language would be in place only for the COVID only vaccine.
You recognize?
That's correct, Representative Smith, that the bulk of the bill, which speaks to schools and COVID, that would be repealed. The other language goes into the section of code that speaks to immunization of school children generally and affects the epidemic language. That part would not be affected by the repeal.
Thank you, Mr. Chairman. And simply, I stand beside I'm happy to support this part of the section that protects parents from a new vaccine. My colleague knows I do believe in vaccines. And I'm not too far off from Dr. Kumar. If you've got a religious exemption, there are already things that are in place for people not to vaccinate their children. There are other things that are available, but I do feel very comfortable leaving the amendment in place just for the COVID vaccine. And we did that intentionally because it's not my desire at all to see any vaccines candidly eliminated from the safety of our public schools. Thank you.
We're still out of session. Chairman Ramsey.
And I'm confused now. I think, so what we're saying is, and I would refer this to our legal analyst, we're going to pass a permanent change to Tennessee Code in Section 2. And essentially all we're doing with the amendment is sunsetting the Section 1. And so in perpetuity, we're going to have this code change in Section 2, and we will have no more control over that. So, am I correct?
Matt King, you recognize?
Chairman Ramsey, that is essentially correct. The repeal affects only the one section. And so the change that is being made to Section 2, which is from the House Education Administration Amendment, that change would be unaffected by the repealer, and thus it would be permanent, subject to subsequent legislation during subsequent general assemblies. But that language would not go back in on the repeal date. It would be unaffected.
Thank you, sir.
Right. Any further questions while we are out? Representative Freeman?
Yeah. And I was going to ask a question I've got so many questions. I wasn't sure who to ask it to. So I'll go to legal. Under current code today, if someone decides not to get vaccinated for any reason outside of COVID, let's say they decide they don't want to get, any vaccination, there is a mechanism and a path for them to get an exemption today, correct?
Matt, can you recognize?
Representative Freeman, I guess I'll speak specifically first to the exemption that's being modified by this bill. That one speaks only to a religious exemption. The language that's being impacted by Section 2 of the bill removes the words "in the absence of an epidemic or immediate threat of an epidemic," leaving only that this section does not apply to a child or parent who thus files the appropriate written statement regarding it conflicting with religious tenets. They have a religious opt-out to those vaccines that are required by the Commissioner of Health for school children. There are some various other similar religious exemptions in the code in other places as well. That's the one, though, that is being impacted directly by this bill.
Representative Freeman.
So if someone today decides that they want to get a religious exemption, they can currently, if the school system decided that the COVID vaccine was going to be required, they could currently, without us changing a law, get a religious exemption and not take this vaccine, correct?
Representative, that in that scenario, no, they would not, because the language "in the absence of an epidemic or immediate threat of an epidemic" overrides their religious exemption. So the way that subdivision, which is subdivision B2 of 49-6-5001 operates, is that the general rule is that you would have a religious exemption or a right to a religious exemption if you followed the requirement to file a signed written statement. However, that religious exemption is overridden during times of epidemics or immediate threat of epidemics. That religious exemption would not apply, and you could not get it during those periods.
You're recognized.
So what does the state define the period of the epidemic, or 'cause we're outside of executive orders? So, and those have expired. When does that terminate, and what's that mechanism?
Matt King, you recognize.
The section does not define how that is to be considered. It just states "in the absence of an epidemic or immediate threat of an epidemic." So it would be left to the plain reading of those words. So it does not have a specific definition to define that and tie it to anything in particular, such as a declared state of emergency or something like that.
You're recognized.
I'm sorry, I just want to make sure I understand. So is this creating a new portion of the code calling back towards an epidemic, or does that already exist somewhere else, and this is tying back to that?
Matt King, you're recognized.
The current language already has in there the language that speaks to periods of epidemic or immediate threat of epidemic. So under current law, you have a religious exemption or a right to a religious exemption, except when there is an epidemic or immediate threat of an epidemic. That's current law. What the bill would do in its current form would, with Section 2's operation, remove the language about the epidemic or immediate threat of the epidemic. So it would allow that regardless of whether there is an epidemic or immediate threat of it, a person would have a right to that religious exemption at all times. The epidemic would not override their ability to exercise that religious exemption if Section 2 were to become law.
You're
Sorry.
recognized.
So under that same definition, I promise I'll finish this up. If we had another increase in smallpox or something like that, and it was deemed an epidemic, then people would be required to get a smallpox vaccine, regardless of their religious exemption. Pardon?
Matt King, you recognize.
Under current law, that would be accurate and under the current way that B2 is written. But if Section 2 of the bill were to become law and remove those words that relate to the epidemic, then they would be able to exercise religious exemption against that vaccine. And also, just to be clear for the committee, B2 is not COVID specific. It is any immunization required by the Department of Health.
Well, we're still at a session on this. Can you give one more clarification? So in the event, to his example from smallpox or something along those lines, and this religious exemption was extended through that period, the amendment does not prohibit the school from screening those individuals or finding some way to protect other children that are in the school that, for whatever reason, can't get vaccinated. Is that correct?
That's correct, Chairman. It doesn't speak to that.
All right, thank you. Representative Smith.
And again, I just want to revisit the scope of this amendment was intentionally directed only toward the COVID aspect of this. So for the purpose of a brand new vaccine that we have 2 currently on the market, actually 3 on the market, 1 is currently suspended in its use. The amendment scope was very carefully drafted to only apply to the section of this bill that was meant to allow parents an opportunity to voluntarily have their children vaccinated, as opposed to having it mandated through the Department of Health here in the state as part of their all the school immunizations. So upon resumption of the school year 23-24, if the COVID vaccine has been FDA approved and there's no other law, then the Department of Health could add that as a mandatory vaccine. But there was no intention of my amendment to expand to Section 2. So it was very narrowly drafted just for COVID.
Yeah.
Thank you.
Thank you. Any further questions while we're out of session? Okay. Chairman Ramsey, you recognize?
And I would like to ask Mr. King, I was comfortable with the idea that this whole bill, having come from education, it was in effect had item 2 or section 2 been addressed solely, it would have come to the health committee, would be my guess. So I feel like we've kind of skirted the issue. Mr. King, could we require that this sunset apply to section 2 as well? I mean, I don't want to offend the sponsor of either the amendment or the bill, but that was my understanding and made the bill somewhat more pleasant to think about.
Matt King, you recognize?
Chairman Ramsey, strictly from a drafting standpoint, we could amend that to apply to any of the sections of the bill that the committee would desire, but I would leave that decision for the committee.
Right. Any further questions while we are out of session? Okay, seeing none, we are back in session. We're on the amendment. Representative Smith, you're recognized.
For the purpose of the amendment, this was to assist our colleague to move his bill and to protect parents from a mandate that was on a currently unapproved vaccine. But I will stand at the will of the committee, and no harm, no foul. But I will tell you, I do think that this is it's logical. It does not require that parents are prohibited from having their children vaccinated. But again, Mr. Chairman, I will renew the motion for a vote and happy to work with the colleague, to move his bill.
Okay. Would you remove unless there's an objection to the motion, you have been recognized. Is there objection to the motion? Okay, seeing none, then we will be voting on amendment 7248. All those in favor say aye. Aye. Opposed? No. Ayes have it. Okay, we are back on the bill as amended. There is a third amendment that has been proposed. Amendment 7398. Okay, Chairman.
Withdraw that amendment. I'd like to make comments on the bill.
Okay, without objection, that amendment is withdrawn. Okay, we are back on the bill as amended. Chairman Whitson, you recognize?
Thank you, Mr. Chairman and sponsor. Representative Grills, I think the world of you. You remind me of one of my favorite lieutenants when I was a company commander, the kind of guy I want to take the hill. But I have serious problems with this bill in regards to government overreach. This bill applies to private schools. It applies to church schools. It applies to home schools. We are now mandating private homes who they have to let into their home. We're telling churches who you have to let into your church. There could be reasons why I would not want somebody who's not been immunized in my home if I'm running a preschool. I might have someone who has health issues. And what this does is just sets up lawsuits. It sets up an intrusion on people's private property. And it's just clearly government overreach. I always may want to call this the Trial Lawyer Full Employment Act. It's what we're doing. And for that, I just feel like that we are telling folks what they have to do. And we've been very good as a General Assembly protecting churches and private property from telling them who they can have in their homes and how many people. Now we're telling them you have to let anybody and everybody, regardless of how they feel about this pandemic or an epidemic, if it's local, what they have to do. And I just feel this is clearly government overreach on people's private property and church property. And I just cannot support this bill as written.
Representative Grills, you recognize?
Thank you, Mr. Chairman. I don't think your lieutenant would appreciate that, but
I'm sorry.
I said, I don't think your lieutenant would appreciate that. He'd want you to support it. But
He was a good lieutenant.
yeah. Anyhow, I appreciate those comments. The bill itself, kind of, it's in code what the church-related school are or is the home schools. It's not just any home. It's not just any church-related school. It's not just any private school. It's already it's codified in 4950-801. I don't know if you've seen that or not, but there are different. It's not just a house or a private home, like you just said there. So I want you to I want to understand too that we're not trying to mandate anything to anyone. We're trying to protect individuals' freedom. And my goal is just that individual liberty is a pillar of our society, and I believe that it's best for individuals in consultation with their doctor to make the decisions that's best for their health. We just have a fundamental disagreement, or we just see things differently, and that's perfectly fine.
I fully believe in individual freedom, but also property rights and who can come in and out of my home. And I don't want the government to dictate to me if I run in a homeschool or a preschool saying I have to let this individual into my home.
For clarification on that, I believe that the bill does not prohibit other screening that person could do, and then they could prohibit them from coming on. They just can't violate a religious exemption for that period. I think that's what we're at. Representative Clemens, you recognize?
Thank you, Mr. Chairman. I just wanted to reiterate some points that were made last week. You know, these vaccination bills that we continue to see, and some of the discourse today fails to recognize the fact that even if you are vaccinated, we need to remember that vaccines don't just protect yourself. Limiting vaccines or doing anything or conducting public discourse or anything to reduce the taking of vaccines poses a large threat to the general public. You know, a large percentage of us wouldn't be here today if children in schools hadn't taken the polio vaccine, smallpox, MMR, whooping cough, these types of things. And while it's easy to kind of forget how impactful and devastating those were, these things have a tendency to reoccur. And when you look at the low rate of vaccination in the state of Tennessee, specifically our rural areas where healthcare is severely limited due to policies or failures of this body, we have to be very careful when we limit or discourage in any way, whether intentional or not, through discourse or policy the taking of vaccinations. This is a threat. This is an ongoing threat, pandemic or not. We have a governor who won't even allow a picture of himself being vaccinated to be used. We won't have several people even mention that they've been vaccinated. This is a dangerous path that we're going down, whether it's in the name of religious freedom or individual liberty or what have you. I just simply, in the interest of our public welfare and health and our children and those who may be infected with this disease or others, I encourage my colleagues to think seriously about voting in favor of legislation such as this. It's incumbent upon us to send the correct message and not discourage things that are available to us, proven by science and reliable to protect the public health and welfare. Thanks, Mr. Chairman.
Thank you. Representative Grills, any comments?
Thank you, Mr. Chairman. Just once again, this is not an anti-vaxxer bill. I'm pro-vaccine as much as anyone, but I just believe that it should be up to the individual and their doctor to make the best decision for their children, for their future. If there are adverse effects because of the vaccine or whatever it is, whatever procedure they have, I feel like it's best for that parent to bear the responsibility and not be forced upon by some bureaucracy.
Chairman Kumar?
Thank you, Mr. Chairman. Just one matter that I wanted to, I don't know if I'm correcting it, but I would like to explain that when we take the technical language and call this quote unapproved, I think it creates vaccine hesitancy. It creates a negative feeling about the vaccine. And let us remember, it is approved for emergency use. And in this pandemic, emergency is what we had. So in that sense, system is working, but we should not use the unapproved effect or calling it experimental. If it is, then once again, 60 million plus people, maybe 80 million having been vaccinated, that has been a successful experiment. Secondly, I would like to say to my good friend, admire your commitment to liberty and freedom, and I think that is true. The country was founded on those values, and it is the greatest country in the world. And as an immigrant, that's why I'm here. Yet, the same religion that we are allowing religious exemption for, I think the same religion also tells us to love thy neighbor and protect others. And in that situation, to say, I'm not going to take the vaccination, and even if I get infected with COVID, I'm still going to come to school, I'm still going to go to work and do those things, then that's not loving your neighbor. That's not how it is interpreted. I find a conflict in that, and I think we should realize that it's a matter of doing the right thing in the face of a pandemic or a calamity. What pulls us through is when we come together, not for some people to take that out that I'm not going to do this, I will let others do it. I guess I haven't been to church in a while, so I had it in me to say that. Thank you, Mr. Chairman.
Thank you for those comments. Any response?
Thank you, Mr. Chairman, and I love you too as well. We just see things a little bit different. And actually, I was at church Sunday, so maybe I'll pray for you this Sunday that the Lord change your heart. How about that, Doc?
All right. Chairman Ramsey, you recognize.
And thank you, Mr. Sponsor. My church attendance is secret. And I understand your passion. This is a very passionate time, and the issues that have come up, we're in the process of passing a similar bill, which some say makes this one unnecessary. The representative or Chairman Hulsey's, and I understand your passion for this bill, and certainly the passion for Chair Lady Smith as she intends to give us a period of time to see that proper protections are in place. But I would ask that we make an amendment to the amendment to make it cover both items 1 and 2. So I'd make that in the form of a motion, because I think this was an amendment apparently that was sent to us from the education. And were that to be brought up, I think it would have been, excuse me, properly assigned to Health Committee. So to keep me from being confused about the intent of this amendment, I would make that motion.
I'll second it.
That's a proper motion and a proper second. Bear with me just 1 second. Chairman Williams, you recommend?
Just a parliamentary inquiry. Of all due respect to my member from Blount County, it's generally not the posture of the committee to take a verbal amendment, much less an amendment that was not timely filed as it relates to this legislation. The fact that this bill went to education first, it still was one of the few bills that's double referred to health. It's here now. The only difference is because the original subject matter had to do with education, which is why it went there first. I don't know that it would materially have changed the bill to have it go to a health subcommittee in addition to this committee. So I respect the chairman's response, but I'm not sure that parliamentary rules allow us to be able to verbally amend a bill unless it's at the will of the chairman. And to my knowledge, I am late. I'm usually here every time, but I hadn't heard this happen so far this year. Thank you, Chairman.
All right. Thank you for those comments. Chairman Ramsey?
And I've repeatedly done this in my committee, which may make me ineligible to ever be a chairman again. But I think I've done it for you, sir, in past. Yes, I've done it for everybody else, I guarantee you. But anyway, the point is that this is an issue, and the situations are that we have a responsibility, the advocacy of our citizens, and the advocacy that comes from the point of view of education and from health are totally different. And so the folks that have been coming to me and talking about it are folks that take care of our children, and not in a education environment, but in a health environment. So this is something that's somewhat new, and I myself am confused. I was enamored with the amendment to sunset both portions, and I thought that's where we were. And of course, anytime a motion is made, it's certainly up to the will of the committee to make that decision. And if the chairman doesn't like it, usually it doesn't get that far. So I'm at the will of the committee.
I'm a point of order.
We're going to take a 5-minute recess here without objection.
It's a proper motion.
Okay. No, it's going wrong. No. Yeah. All right, we are back in session. Okay, we do have a proper motion and a proper second. It is not the purview of this committee to make verbal amendments on the fly. And so an amendment would be untimely filed. So without objection, we are going to roll this bill to the heel of the calendar with the intent on hearing it tomorrow.
Thank you, committee. Look forward to seeing you guys again tomorrow.
All right, that brings us to item number 2, House Bill 1132. Chairman Farmer, you are recognized.
Thank you, Mr. Chairman.
Thank you for your
Committee.
patience. You have a motion and a second.
Thank you so much. There's several amendments that's been filed, Mr. Chairman.
Right.
And if we could, I'd like to move forward with House Amendment 7289. It makes the bill.
Okay, Amendment 7289, you have a motion and a second on the amendment.
Very good. And Mr. Chairman, last week I had a short 3-page slide was on the screen there. Is it still, you think it's still somewhere?
I don't know that we have it up here, but we do have that the Attorney General is it on our iPad?
It was up last week. It would help. It would help the members understand the breakdown if they could see it.
I don't know that we have it up here this week. Is there anyone that can help us get it up there? Okay. Sorry, we don't have it up.
Okay.
Up this week.
Okay, that's fine. And so I'd just like to move forward on House Amendment 7289, and I'll explain it the best I can. And if any of the members need copies, I've got a 3-page slide that shows the breakdown. If you're a visual type person that understands things better that way like I am, then may help. So, but I'll try to explain it the best I can.
All right, thank you.
So what this amendment does, it creates an opioid abatement fund to dedicate certain funds from opioid-related settlements and other resources to abatement. Creates an opioid abatement council that will obtain broad input regarding the best use of abatement funds and make funding decisions. And it establishes a procedure to allow the state to enter into settlement agreements to resolve the claims of all governmental entities to maximize the funding available in those agencies. And what that means is this, folks. This legislation allows the state, the Attorney General's office the state, the abatement fund, which is the abatement council, which is going to be set up of, it's going to consist of 15 members. Okay. The governor is going to be able to pick 4 of those members. The Senate Speaker is going to be able to pick 4. The House Speaker is going to be able to pick 4. And the counties are going to have a choice of 2 members, and the cities are going to have a choice of 1. The settlements are only going to be from the settlements of 4 entities only. And those are those distributors, and they are McKesson Corporation, Cardinal Health, Amerisource Bergen, and Johnson & Johnson. So any settlements from those 4 will then flow into the council in these ways, okay? Out of that 100%, 15% will go down to the state, 50% will go down to the counties, and 70% will go into this abatement council, okay? So you got 70, 15, and 15 from the settlements of those 4. Out of that 70%, 35% of that 70 will be redirected back to the counties, okay? And the local municipalities, all right? And then the remaining portion of that will then be used by the abatement council basically to make those distributions to the municipalities. Okay. So it's essentially going to be a 60-40 split. 60 state, 40 counties, cities. And the most important part about this is that this is by agreement. Okay. We've worked hard over the past couple of weeks, worked with Will Denami, Mike Harrison, worked with Beth Winstead, worked with Gerard Stranch. Gerard is an attorney here in Nashville that represents the majority of the litigating district attorneys, cities, counties across the state. Okay, so this split started out where the cities and counties were going to get 15%, state was going to get 15, and then 70% was going to roll through this abatement council. But after everybody got together, sat down, and we've discussed it over the past couple of weeks, this is the split everybody's agreed on. So I can come in front of this committee and tell you all that there's not been one person that I've spoken to that we have not worked with, meaning the Attorney General's office, myself, and those folks who represents the counties and the cities and the litigating parties across this state. So I couldn't sit here and tell you that there's one person that's opposed to this, because I'm not aware of one person that's opposed to this agreement. So that's what we've come up with. That's just your 10,000-foot overview of what this amendment that makes the bill does. And I'll be happy to answer any questions that y'all may have. But it's only regards to these 4 entities that I had spoke of, the 4 distributors. Those monies will come into the abatement council. They'll be split up in those ways, and we'll end up, doling out the monies that way.
Right.
So,
All right, thank you. Representative Smith, you're recognized.
Thank you, Mr. Chairman, and you're going to have to beg my forgiveness because this has kind of been a moving target.
Yeah.
From my county mayor, I've been hearing 50-50, and to dig in and don't budge from there. If you wouldn't mind kind of offering how it was that this 60-40 came to be, only because while I don't disagree with having a generic council, what I will vote against and speak against and work against is for there to be suddenly a new fund created where monies are appropriated into areas that have not had a real struggle with opioids. I want to make sure that the money that is being awarded through these suits is going to the places, like I'll give you for instance, if begging your indulgence, we had a TANF working group. During that window of time, during the TANF working group, we found that the disproportionate distribution of funds was Shelby County, Davidson County, a little bit into Hamilton County, a little bit into the Northeast, and hardly anything in the rural spaces. And I think that we're all very aware that the opioid crisis has hit every county, and some counties even a little more disproportionately, not just the urban core. So if we could, Mr. Chairman, have some assurances as to how this money will be distributed, as well as to read into the record and speak into the record the intent of this council to make sure that we're not creating an urban fund of entitlement or whatever. I want to make sure that this money is used appropriately. Thank you, sir.
Chairman Farmer, you recognize.
Mr. Chair, if we could we go to session here from Mr. Slattery and his attorneys on this? I think they're well prepared to answer these specific questions in regards to that.
Absolutely, Ed. I was going
That'd
to
be
ask.
fair.
I was going to ask that question and bring that up. So, without objection, we will go out of session. Thank you, General Slattery. For the record, give us your name and title, who you're with.
Yes, Mr. Chairman, Herbert Slattery, honored to be the Attorney General of our great state. Thank you for giving us an opportunity to speak to this important bill. We've actually been involved with this since for about three and a half years trying to reach this point, and we really need your help on taking it across the finish line. But as to Representative Smith's particular question, the funds that there'll be 15% that'll go to the counties, and then the counties, and I'll say counties, local subdivisions have total say over that. There are no strings attached to that 15% bucket. But the 35% that is coming out of the abatement bucket has to be spent to abate the problem. And so those funds and the local subdivisions will divide that up in accordance with certain criteria. They might use, MMEs, overdose deaths, things like that. But the whole idea is to use that 70% fund to solve the problem, to address some of these issues that we've been living with for so long. But that's the idea behind it. And I may say one other thing. What we're trying to do with this is create a structure. Everybody's been focusing on the settlement with the 3 distributors and 1 manufacturer, Johnson & Johnson, as they should. That's an important settlement. But there are going to be other settlements, one of which we're going to receive some money in the probably the next couple of weeks. But those monies will flow. That's a states only deal. So those monies would flow into this same abatement fund that will be managed by the treasurer, and it will be dispersed by the abatement council along the lines that Representative Smith is referring to solve the problem. Purdue Pharma has been in Chapter 11 bankruptcy for a number of months, and they have filed a reorganization plan that will be voted on, and we think there'll be somewhat of a distribution from Purdue Pharma by the end of the year. That's our best guess. Those funds dedicated to abatement will come into this structure. So it's a structure designed to address not only this one settlement, but a lot of the other settlements, so that we have a good structure in place, and we know that those funds will be used to solve the problem.
Chairlady Smith.
Thank you, General, and thank you, Chairman, and thank you. Help me with the math. I'm hearing 15%, 35%, 70%. If you could just walk us through again, Chairman Farmer did a really good job with, trying to walk us through that. But since you were kind of in charge, walk us through the math. Thank you.
He did a very good job. It's complicated, and I apologize for that, but it's the most complicated thing we've worked on probably anywhere in the country, to be honest with you, if you ask the attorneys general. But okay, as Chairman Farmer said, there are 3 buckets. There's a 15% bucket, and then there's a 70% bucket that's going to be used solely for abatement, and then there's a 15% bucket. Those 2 15% buckets have no strings attached to it. 1 bucket goes to the state, 1 bucket goes to the local subdivisions. No strings attached. Okay. Now, of the 70% bucket, the abatement bucket, 35% of that 70%. And that's key. 35% of the 70% will be earmarked for local subdivisions to be used for abatement. So Representative Smith, where local subdivisions will end up at 39.5%, and then the abatement bucket, and then the states will be the balance.
Representative Smith, you recognize?
So let me recite this back to you for the purpose of us understanding this. So 15% is local, 15% of the total is local, no strings attached. 15% is state, no strings attached. 70% is for abatement. 35% of that 70% goes to locals that's earmarked for abatement, and 65% goes to the state for abatement. So clearly, the state continues to get the largest sum, and is that already budgeted out for? Because what I think most of our colleagues want to make sure is that money is resourced and mobilized rather than institutionalized into government. Thank you, Mr. Chair, for your indulgence.
Thank you. And yeah, just to follow up on that, and that was the couple of questions that I had from my county as well on that. It's the 35% of the 70%, which gets into 39.5. That's used on the abatement. My question to you is that 15% that goes back to the locals, they could use that funds towards their own attorney's fees that they've had. Is that correct?
Yes, Chairman.
All right, thank you. And then the 70%, or excuse me, the 65% of the 70% bucket, what strings are attached to that?
The same. It has to be used for abatement. It'll flow through the council, who will decide what particular programs or projects or treatments or et cetera actually work to solve the problem, and then they will allocate those funds proportionately to solve the problem. And we all know that there are certain areas that really have a deep problem and certain areas that don't, but they'll take all that into consideration.
All right, thank you. Representative Freeman, you recognize? Okay. Chairman Williams?
Thank you, Chairman. Thank you, General. So if the state, if through your guidance, we settle for $10 million, you're telling us that it looks to be $3.95 million of that, or 40%, is going directly to the locals subdivision unencumbered.
No, no, we're not saying that. The total money would go 39.5%, so that'd be $3.95 million would go to local subdivisions. But let's see, you take out the 1.5, so you've got 2.4 million that will go to the local subdivisions, but will be earmarked for abatement.
So I guess the confusion that I have is, first of all, there were two things that are important to me in my district. One was my general was one of the district attorneys, much like the other two, that before the attorney general wanted to be, and your office wanted to be involved in opioid lawsuits, they settled lawsuits, or they filed suit on behalf of counties. And so it's my understanding that all those lawsuits that are out there as it relates to one pharmaceutical company, Endo, all those lawsuits are not a part of this settlement. Is that correct?
The lawsuit involving Endo is not a part of this settlement.
But you did state in your testimony a moment ago that the money that comes from that settlement will still go into this fund.
You recognize?
Well, if I did say that, I wasn't accurate. I was saying that the settlement funds that the state gets from other settlements will go into this fund. We have settled one against a consulting firm, for instance. That's a state's only deal. That will go into this fund. Purdue Pharma, a portion of that will go into this fund. And what I'm trying to say is there are a number of settlements that probably will go into this fund, not just that one distributor J&J deal.
You recognize?
Okay. So when you were commenting that money, those monies for these, when you said additional suits or additional things outside the three distributors and one manufacturer in this agreement, I misunderstood you to think that those other ones that were carved out for those three would also go to the abatement. But you're talking about another or a third pool of entities outside the original district attorney's filings and this federal filing as it relates to the three distributors, one manufacturer. Is that correct?
Correct.
Okay. So I left last week, and the understanding that I had was that it was going to be 50-50, not 60-40. Could you explain to me why it's 60-40 and what the benefits are for the state and the locals to do it that way?
You recognize?
Well, it was I think a matter of negotiations. There are a number of states that have addressed the issue. Kentucky had the 50-50. That was only on that one settlement. Kansas, for instance, had 75-25. So I think it was just a question of negotiating and discussing who had the better claims. And reaching some sort of an agreement. Now, a lot of those conversations, frankly, we were not a party to, because those are decisions for you all to make. We thought as to how you wanted the money to flow and who had control over it and that kind of oversight.
You recognize?
Thank you. For the record, this is the first discussion I've had, and the 42nd District has had about the distribution of those monies, and I was not involved in the discussions. I'm just hearing them secondhand, I suppose. It concerns me a little bit that you weren't involved with those, General. Thank you.
You recognize?
Well, We made suggestions. We helped with the language of the statute. We were not privy to every discussion and every piece of negotiation on legislation like we normally are. We're normally not in that, but we've engaged at the point where we needed to engage and relied upon leadership to bring us to the point where we are now.
Okay. Thank you. Speaker Marsh.
Thank you, Mr. Chairman. Thank you for being here, General, and thank you for your hard work on this. And I've heard too, it's a moving target all over the place, but after talking with some of the folks with the County Mayor's Association, I think they're all pretty well satisfied the way this has worked out. And the way I understand it, the first 15% that goes to the cities and counties can be used in any way. I think the way Mike Harrison says, you could plant flowers around the courthouse with that if you wanted to. But my question to you is, who makes up the abatement council and who picks those people?
There are 15 members. They're all to be qualified within the particular industry and profession so that they're familiar with opioids, the epidemic, how you treat things, treat people. And we want them to have those kinds of qualifications for a number of years. They'll be picked, they're selected, 4 by the lieutenant governor, 4 by the speaker, and 4 by the governor. And then the 3 remaining ones are selected by the local subdivisions.
Thank you.
All right. Chairman Kumar.
Thank you, Mr. Chairman. Thank you, Mr. General, for coming. Maybe a little repetitious, but the funds, it appears that they are restricted funds. They are to be used for certain purposes. Is that true?
You recognize?
That's correct.
Okay. Can you, in a nutshell, outline for us what those funds can be used for?
You recognize?
Mr. Chairman, with your permission, I would like to introduce Michael Leftwich, who's an executive counsel in our office who has worked on that. There actually is a 13-page set of projects and programs that have been worked on nationally that the council could select from, but he could probably speak to that a little more specifically.
Yes, my name is Michael Leftwich, Executive Counsel with the Attorney General's Office. And there has been discussion about what qualifies as abatement and remediation that has been going on for several years. And the goal has been to be very broad with what qualifies. What would qualify for Tennessee would be left to the Opioid Abatement Council. That is one of the things it is tasked with. And the legislation has a number of requirements for that council to get out into the communities. It needs to meet in each of the grand divisions. It needs to have input from communities and experts and educators. And there are a number of other requirements because what we want is a transparent process in which the council learns about the problem across the state in different communities and gets a lot of input about what's needed and what programs work, what doesn't work, and takes that into account. And so the council for Tennessee will be determining. At the national level, it has been important to have dedicated funds to abatement for the companies we're dealing with and in talking to the subdivisions and working out these agreements. And that list that we're working off of nationally as what is abatement includes everything. Obviously, it has treatment, it has educational programs, it has drug courts, and as the General mentioned, it is a 13-page list. The council doesn't need to adopt that full list, but we have identified dozens and dozens of types of programs, evidence-based programs that would qualify as abatement.
Thank you. Thank you. Thank you, Mr. Chairman.
Thank you. Representative Alexander, you recognize?
What happens with all the lawsuits that are already out there? Like, we've got lawyers that are representing 13 counties up in our area.
You recognize?
Well, there are a lot of lawsuits. We agree that some of those, the ones that you're talking about, are also the ones that Representative Williams raised that involve the DAs. That they have a lawsuit, several lawsuits against Endo, one manufacturer. Those would continue. The lawsuits against Purdue Pharma they're in bankruptcy, so all those claims are now in the bankruptcy court. They'll decide how those go, but those lawsuits will be eventually dismissed. The lawsuits against against distributors and J&J, there'll be a process, but that's what we're trying to get settled. So at the national level, those four companies are going to have to decide on a term sheet, and is that a sufficient settlement structure? And then they're going to be in order to do that, there'll be a number of states and a number of counties that would sign on at that level, and then there'll be a second step where the local subdivisions are asked to sign on. And then the third step is and the companies have to decide, are there enough states and are there enough local subdivisions to sign on in order for us to agree to this global settlement? And they're trying to get, as Michael said, they're trying to get global peace. So there's a threshold, we don't know what it is, a threshold number of states, a threshold number of local subdivisions that would be required for that settlement to go forward. And they'll make that determination. So if they're sufficient, then they'll get releases from the people who signed on. And then at some point, if there are a smaller number of counties, there's a provision in this bill that says that with respect to just that settlement with the distributors, and this is really important, just that settlement with the distributors and Johnson & Johnson, then the Attorney General can release the claims of those local subdivisions if he gets the approval of the governor and the comptroller. So we got to get three people to agree to that one particular release provision. But if we do, then the settlement, and gets complicated, I'm sorry, but that settlement has certain bonus provisions and certain what we call moratorium. Each of those, if we don't have a sufficient number, or if lawsuits are filed later, the amount of money coming to the state goes down. With that particular release, we get all the money. We get 100% of it. The way it's structured right now, which means that the local subdivisions will get 100% of the money. And we won't be subject to it declining or being reduced or held up. I'm sorry for the complexity. I hope that addresses your question.
Thank you, sir. Thank you.
Thank you. Representative Clemens, you recognize?
Thank you, Mr. Chairman. Thank you, General. Does this statute or the way that we're distributing these funds require court approval?
Require court approval? No.
So we really have pretty wide discretion to do with these funds resulting from this specific settlement, however we wish.
So long as it's used for abatement, and he was specific on what those uses were, yes.
Okay. And can you speak to the distribution, the 15 to the counties and 15 to the state with regards to the distribution? Is that going to be a pro rata distribution of funds? How's that 15% going to be divided among the 95?
Well, that'll be subject to the way that they're discussing things. Michael, they have worked out some on the national level regarding local subdivisions. Of course, the state money will go into that abatement fund, and the abatement council will determine how to allocate those funds.
Well, sorry, who is they when you refer to the county distribution?
Yes, the issue is the settlement agreements are not finalized at this stage. And one of the remaining issues to be put into the final agreements with these three distributors and Johnson & Johnson is how what's called the subdivision bucket would work. Generally, the expectation is, and I'm almost certain it would work out this way, is that metrics would be used based on the opioid crisis, things like the number of prescriptions as measured by MME, the number of overdose deaths, and population would be used to divide up that fund nationally for the subdivisions. But it is something that has not been finalized, and so we can't be precise as to exactly what the formula would be for the subdivisions, but they are the ones controlling that conversation. It's just that we don't have it in place in an agreement because things are not final yet.
So the decision about the distribution of the 15% to the counties or locals is going to be made at the federal level before the settlement is finalized for all 95 counties. So Bedford County is going to get X amount percentage in that federal agreement.
You recognize?
Yeah, it's less of it. It's at the national level because we're talking about what would be in the national settlement agreement. Now, what we would hope happens, and so it's going to have default provisions. What we would hope happens is between now and everything being finalized or implementation is that within Tennessee, the state and the local subdivisions would come to an agreement about a number of remaining things that would then replace the default provisions. That's what we're anticipating will happen. That's what we hope would happen. And in that case, we would very much have a Tennessee-specific plan for how the subdivision 15% is allocated among the subdivisions. So that's what we want. Where we are right now is we don't yet have that agreement, and we also don't have a final agreement with the national settlement. So the priority would be you're going to start with default provisions in the national settlement, and the subdivisions will determine what that breakout is. We would like to pretend to be very Tennessee specific, have an agreement with the state and the subdivisions to be specific about allocation for the subdivisions. That's what we would hope would happen, and that's what would control that subdivision bucket. Either way, we're talking about subdivisions not only being involved, but really driving how that allocation split is done. We have worked a lot at the state level, how that's done, but we don't want to dictate about the subdivisions on that part of it. We want to work things out, and hopefully we will have a specific Tennessee agreement.
Okay, thank you. The general, the 15% going to the state, aside, not including that 70% abatement, the 15% to the state, that also has no strings attached, correct?
You recognize?
That's correct.
And can that go to the general fund?
You recognize?
Yes.
And aside from getting to my friend from Putnam County's question, are we only specifically limiting the other language to that one settlement with those entities? Are we going to have to come back and pass additional legislation for future settlements?
You recognize?
That's a possibility.
Okay, thank you.
Thank you. Representative Hicks, you recognize?
Thank you, Mr. Chairman. Thank you for being here from the AG's office. This bill, I have a lot of concerns about it. Seems like to me, being from Northeast Tennessee, I know that Tennessee, the opioid epidemic hit all the way across the state. There's no question about that. But being from Northeast Tennessee, it hit us extremely hard. And seems like so far, the cure that the state has come up with is more opioids. And so this bill concerns me. It not only the bill, but just there's a lot of unanswered questions here. I would have liked to have seen more, on how the money is going to be distributed. We can go with numbers, math all day long. That does not concern me any whatsoever. It's exactly the entities and how we're going to go about treating the problem that we have. And I'm speaking as a recovering addict that works with recovering addicts. There's a lot of ways it's going to be a lot of money, and there's a lot of ways that this money can get wasted. And, we hear all the time, going through the state and just it can really create a big problem. So I'm very, very concerned. I'd like to have more time to sort of see, how this money will be distributed. On the council, I think there needs to be accountability. I think that, we may need to have a few legislators on that council. I don't think it would hurt a thing. So that's some of my concerns, and I just hope, we'll see how this goes. Thank you very much for being here. Thank you, Chairman.
All right. Thank you, General.
If I could respond just to one issue that you brought up, the legislators, in all likelihood, could not serve on the council because it would be a second position of trust under the Constitution, which you're not allowed to do. So we thought about that, but actually were advised by legislative legal that was not something that they wanted to do because there would be a second appropriation of money in that instance. And there's a second, so that's something that we couldn't do, but I just wanted to address that one.
All right. Thank you. We have multiple people still left on the list. Would you be able to come back tomorrow to answer more questions or go through other, meet some other members and get some of their concerns taken care of? Appreciate that. Okay, so without objection, we're going to go back into session. And with that, I was going to ask the sponsor, we're about to run out of time here. Obviously, we'll be rolling this till tomorrow, coming back tomorrow at 2:00. Without objection, you good with that?
No objection. That'd be great, Mr. Chairman. Whatever committee wants to do.
Representative Williams, you are recognized.
I don't want to get out ahead of the committee, but I don't think the amendment language is going to change, but it'll be in the dashboard and the public can see it if we adopt the amendment probably. And then roll it. I didn't know if the chairman might want to do that since it's timely filed and the members and our colleagues could be able to see that amendment language on the bill.
That's okay. Without objection, let's vote on Amendment 7289. All those in favor say aye. Aye. Opposed? Ayes have it.
One thing.
You're recognized.
And I found this out. The slideshow that I had mentioned, we can't have these props behind us, evidently new House rule. But as I understand, it's been emailed to every member. If you all just take a look at that, it may help you kind of digest and understand how these monies flow. That when we come back tomorrow, we can maybe on the same page, and I won't make it as clear as mud. So,
All right. Thank you. All right. So without objection, we will roll this till tomorrow.
Thank you.
Thank you. Before we adjourn, we have 1 minute. Representative Casta, you are recognized on House Bill 370. I need a motion. Second. We have an amendment number 7113. Is that correct? Okay. Okay. We have a motion, a second on that amendment. That amendment makes the bill. Briefly give us that, and that is has been approved, given to you by the Department of Health. They are good with that.
That is correct. That is correct.
Okay.
And so the Department of Health will post from the county health departments the number of total tests after a epidemic is declared, the number of tests that are given, the types of tests used, the number of outbreaks, and the number of asymptomatic cases. So the purpose is to get information out in a public setting on what is being reported to the Department of Health. That's all it does.
Okay. All right. Any questions on the amendment? Okay. Seeing none, we are voting on Amendment 7113. All those in favor say aye. Opposed? Ayes have it. We're back on the bill as amended. Any questions on the bill? Seeing none, we are voting on House Bill 370 as amended. All those in favor say aye. Opposed? Ayes have it. Bill goes on to government operations.
Thank you, Mr. Chairman and committee.
Okay, we will recess until tomorrow at 2 p.m.